we're very pleased today to be joined by Peter McQueen and Joe Delaney, who I think, as all of you know, are Australia's current representatives to the ICC Court. And they have kindly agreed to share some reflections on their time on the court with us today before they hand over the reins to new members later this year. So thank you, Peter and Joe, for joining us today. Peter, perhaps you can kick us off today by just explaining a little bit about the role of the ICC Court.
Sure, Carmel. Good afternoon and good morning, and maybe good evening somewhere to everyone on this broadcast. The role of the ICC Court. Well, you pick it up in the ICC rules. I hope you've all got yourself a copy of the latest 2021 rules. Jo has one. I think she puts one under her pillow every night. Basically, our role in the court is to ensure the application of the rules themselves, noting that the members of the court are independent from the ICC national committees and groups. That really is the role, and the main features of what we do on the court. We're involved with the appointment and confirmation of arbitrators. We're involved with the challenge of arbitrators, and we're also involved in the scrutiny, as it's referred to, or review of the draft awards. And realistically, I think it's that role which is probably the most takes up most of our time. Although increasingly we've seen more challenges over the 6 years which we've both been on the court. As to the scrutiny process, the rule is quite clear. The court suggests modifications as to the form, but not as to substance, but can actually refer attention of the arbitrators or the tribunal to points of substance. I'm sure Joe will speak more about that when we get to the scrutiny of the awards. How do the court sessions work? Well, there are two types of sessions. There's a special session, which is made up of at least 6 court members and a president or vice president, and they deal with matters relating to which involve a state party where there is a dissent. They are probably the two major reasons why, and also challenges as well, why those matters would go to a special session. They're held less regularly than the general committee sessions, which are made up of three members, 1 president and a vice president, and 2 members. And the workload of each in any session, there's an agenda of between probably 5 to 12 matters, with a variety of scrutiny of partial awards, for full awards, and also challenges, as well as other more administrative functions at the committee level. I think with that, that's enough by way of opening, I think, Carmel.
Thanks, Peter. So just delving into the first of those things, which is the appointment and the confirmation of arbitrators. Joe, direct this question to you. This seems like something which should be fairly straightforward if the parties have nominated the arbitrators, but what kind of issues arise that the court needs to deal with?
Thanks, Carmel. So Article 13 of the ICC rules do provide that all arbitrators who are nominated by the parties are then appointed by the court. Of course, the court will also appoint arbitrators who have not been nominated by the parties and need to be appointed to make up either a tribunal of 1 person or a tribunal of 3 persons. When a party has nominated arbitrators, the court will still look at those nominations. Sometimes it might be that the counterparty, so if the claimant has nominated an arbitrator, the respondent will challenge that nomination or raise issues with the disclosure statement that's been submitted by the arbitrator. And in those circumstances, the court will consider the comments that are made by the respondent. It's not actually a challenge of the arbitrator, but if the respondent says, for example, that they're concerned about the disclosure statement, which means they're concerned about independence or impartiality, then the court will look at that with a view that the court needs to determine whether or not it's appropriate to appoint that person or confirm the nomination, just in case there's going to be a challenge later down the road. And sometimes those types of considerations are very borderline, and the Secretariat will provide to the court examples of previous cases that either support the confirmation or indicate that in previous cases in this type of circumstance, they have not confirmed the appointment, and they'll set out the reasons for that. The court will consider those previous cases, discuss it with the Secretariat, and come to a decision as to whether or not to confirm the arbitrator. I've seen examples where that has occurred, the appointment has been confirmed, but then later down the road, a challenge is made by the counterparty, say in our example, the respondent, and then the court needs to hear the challenge on the basis of a normal challenge of arbitrator's process, which we'll talk about later on. So it can be quite important to consider the actual persons being nominated by the parties. If there's also the circumstance when the court is actually doing the appointment, and sometimes in those circumstances, the Secretariat will provide a number of people that the Secretariat has considered. The Secretariat will have put that list together by consulting with various national committees, and the national committees will have provided some recommendations on who could be appointed. 2 or 3 or 4 people might be suggested to the court, and then the court will consider who's most appropriate. And in doing that, they'll look at who has got the qualifications and experience for this particular matter, how many appointments, how much experience they've had in the past, whether or not that's relevant to the particular case, whether it's relevant for someone who's more experienced or less experienced, and then also obviously look at their disclosures.
Thanks, Joe. And Peter, what about challenges to arbitrators? I can imagine that might lead to some lively discussions.
Indeed it does. Indeed it does. We've even got to the situation that's referring to Joe's reference to close calls, but we've actually have gone to the vote on a number of occasions in respect of deciding whether we uphold or do not uphold the challenge. If I could just refer back to the actual the rules, Article 14 talks about challenges. Is a challenge of an arbitrator, whether for an alleged lack of impartiality or independence or otherwise. That's not just impartiality or independence. We have a lot of talk about or otherwise as to what in fact that means. And we're given a body of prior decisions of the court, which are very helpful to us when we're coming to our decision as to the particular the challenging question. So the challenge shall be made by submission to the Secretariat with a written statement specifying the facts and circumstances. The parties, of course, do have a legitimate interest in being fully informed of all the facts and circumstances that may be relevant in their view to be satisfied that an arbitrator or prospective arbitrator is and remains independent and impartial. Of course, that's disclosure, and keep on disclosing. We know all about that. If in doubt, disclose. And also the parties, if they so wish, can explore the matter further and take initiatives contemplated by the rules in respect of this investigation process. But at the end of the day, an arbitrator or prospective arbitrator must disclose in his or her statement the time of the appointment, and as the arbitration's ongoing, any circumstances that may be of such, and we look at this a lot of the time, that may be of such a nature as to call into question his or her independence in the eyes of any of the parties or give rise to a reasonable doubt as to his or her impartiality. Any doubt must be resolved in favour of disclosure. So yes, they're very lively discussions, and you'll see from just what I said, there's quite a bit for the court to consider, and often there's quite a bit of reading to do, because we can get, I think I've seen a 52-page set of papers relating to the correspondence going on between the arbitrator who's challenged, the other members of the tribunal. So it's a very like all aspects of what the court does, it's a very robust process.
Can I add a couple of examples, Peter? Because I've done a couple of reports on challenges of arbitrators. And as you say, sometimes the background papers are very voluminous. And for one matter I did, it was very high stakes. It had been running for a very long time. the background papers, which involve the submissions from the parties and submissions from the arbitrators as to whether or not they should be challenged. It took me more than 10 hours to do the report. It was a very confusing case to, just to trawl through the material and make sense of it. I then spent a long time doing the report and tried to set it out clearly, and it was a little bit longer than normal, but once I then set it out clearly, explained it to the committee in the session, I was then hoping for a long discussion about this particular case because it was very complex. It turns out there was no discussion. Hopefully it was because I'd done a good job in the report, but it just goes to show how important also the background work is to the court members, what the court members do in the committees. So the Secretariat had provided me with a very comprehensive agenda, but then doing the report, it assisted the court in them assessing what to do. They had the report beforehand, and it did make the process a lot shorter. Having said that, we've both been involved in very large plenary sessions where there are more than 150 people attending. Before COVID, that was in person, and I remember that was our first session we attended 6 years ago, where there was more than 150 people discussing a particular challenge, and it went to the vote.
Can I just add that as regards the success rate of the challenges, it's very low. I think we do get increasing number of them, as I've mentioned, and surprisingly, the challenge is going to from day one or even after the final award has been issued. So the full time scale of an arbitration is potentially subject to challenges. And I suppose from time to time you have to start thinking about guerrilla tactics, but we won't go into that today.
It sounds like certainly a very interesting aspect of the court's work.
Yeah. Lively is the word.
Lively. Joe, moving on to the review of draft awards, which I think is another big aspect of the court's work. Could you explain a little bit more about the purpose of the review process and how it's carried out?
Thanks, Carmel. So the review process is often the process that's criticised the most from those that are not necessarily involved, and understandably, may not have been through the process and appreciated the purpose of it. So the main purpose of the scrutiny process is set out in Article 34 of the ICC rules, and that indicates that the court can provide modifications or suggestions to the tribunal on the form of the award without affecting the tribunal's liberty of decision. And they can also draw the tribunal's attention to points of substance. So sometimes there's a myth that the court is going to change the decision or it's interfering with the decision. There can also be a myth that the process is going to delay the issue of the award. Having been involved in this process now, the main focus of the court, I would say, is really to look at what potential changes might need to be made or what suggestions might need to be put to the tribunal to ensure that the award will not be set aside or that it's enforceable. The obvious example that's always given is that the tribunal might refer to a particular case or authority, and it may not state in doing so whether or not the parties have actually considered that case or authority. So the tribunal may not refer to the claimant's submissions or may not refer to the respondent's submissions. They may just refer to the case. And in those circumstances, at least in common law jurisdictions, there would be a concern that enforcement could be challenged on the basis that the tribunal did not give the parties an opportunity to be heard and that there was no submissions on that case. So usually when that happens, the suggestion is made by the court, that goes to the Secretariat, who then pass that suggestion on to the tribunal, and the tribunal will be asked to consider, was this particular case considered by the parties, and if not, should it be considered by the parties? So that's the obvious example. And in that type of example, you're obviously not interfering with the decision of the court, of the tribunal rather, you're just asking the tribunal to ensure that the cases and authorities are referred to in the submissions. You're trying to ensure also that the party submissions, to the extent that you can tell them from the draft award, have been considered by the tribunal. And then you're also trying to ensure that the reasoning makes sense, essentially, that it can be followed. And to that extent, that's where the court might not interfere with the substance, but provides suggestions on the substance if the reasoning is not very clear. The process, I would say, doesn't usually delay issue of the award. If it does delay it, it's because the award is not approved by the court, and that would indicate that the award needs a lot of work. And in those circumstances, if the award needs a lot of work and it needs to go back to the tribunal, then it's potentially an award that could have been set aside or may not have been enforceable. And so that's obviously the whole purpose of the scrutiny process by the court.
But I just add that on this question of enforceability, it's a very important, it's front of mind, and often we have to think of the consideration of enforceability both at the place of arbitration and also possible most likely places of enforcement, and therefore members of the court who have an understanding of the jurisprudence of those courts, both the supervisory and enforcing courts, come into their own to assist in making comments as to enforceability.
And interestingly, most awards have some comments, and those comments might be just minor suggestions by the tribunal, but it's fairly rare for an award not to have any comments. Having said that, most awards are approved, but subject to the comments. And the range of comments might be from very minor comments to deal with relatively minor aspects of the award that are not necessarily so easy to follow, or it might be to do with a case, as I mentioned, or it might be something a bit more of substance. Sometimes it just might be something of structure. For example, in civil law decisions I've read, there's hardly any description of the actual case. What is the actual dispute about, and there's no summary at the beginning of the award that sets out the dispute. They simply go straight into what is the relief sought by the parties, and then straight into deciding that relief, and a little consideration of what the actual dispute is about. That's fine for the parties, but not so easy for a third party to understand.
Also, the tribunal members are helped with a checklist, a pro forma template checklist, which you can find on the website, to assist them in ensuring that form is complied with. And just whilst we're talking about the website, the ICC website has a fantastic amount of information, both for arbitrators and for counsel. And indeed, the one which I'd really like you to have a good look at, it's just been recently redone, or recently being January 2021. It's just the other day. It's the note to parties and arbitral tribunals on the conduct of the arbitration under the rules. It's a very useful document for all those dealing with ICC arbitrations.
And James, just addressing your question about whether it's all form and no substance, I think it really depends on the particular award. If it's all form and it's just some suggestions on form, then that's something that can be addressed quite easily by the tribunal if they want to. Not all suggestions are taken on board by the tribunal, but at least the court has made those suggestions, and the Secretariat will discuss them with the tribunal. If there are issues of substance, it's only usually focusing on issues that might affect enforceability, or occasionally there might be an issue under the local law, and there may be a concern that the decision is not consistent with local law for some reason. They'll ensure they discuss that with a court member who has experience of that local law, and then try to figure out a way whether or not it's a suggestion that should or should not be made. And that's primarily to fit within the terms of Article 34, where they're trying not to affect the decision, but at the same time draw attention points of substance to the tribunal.
So one final question from me, which I'll direct to both of you before I open this up to the floor, is just what are your key takeaways from your experience as members of the court, and have those takeaways changed the way you yourselves practice arbitration?
Joe, do you want to have a crack first? Joe,
I think
do you want to go?
one of the first points, at least, to make is I was really surprised by the diversity of parties, their lawyers, and arbitrators. It's not necessarily, and I would say very high percentage, 60%, if not 80% of cases I've seen are not the law firms you would expect, are not the arbitrators you would expect. Many cases are by local law firms and by local arbitrators. They have experience of arbitration in some, to some degree, or some experience of arbitration. It may be the case is small, it may be the case is of a higher value and more complex, but really there's a huge diversity of people practicing arbitration. And across the globe, in all countries, the seats vary across the globe. I think the ICC says there's something like 120 seats we used last year. So it really just goes to show how many different arbitrations are being conducted around the world, how diverse the legal practitioner pool is, and how diverse the arbitrator pool is.
Could I just make two points? The first one, really, it's all about what struck me most upon arriving and throughout the 6 years has been the thoroughness, the completeness, and the robustness of the process, and noting that many eyes read all of the drafts and all the challenges. That's between the eyes of the members of the Secretariat and the eyes of the court. So that has been, I think, the most outstanding impact to me has been that. And the second point is the role of the Secretariat, including its case management teams, who have this vast depth of knowledge and understanding about how the rules work, how the process works, but also can draw upon the history of the experience of everyone, and also the stored references, precedents which they have, which can assist both members of the tribunal when they're stuck, and also counsel when they're stuck. And I would really encourage all of those parties to ensure, if they do have a problem, that they don't hesitate to contact the case management team in question to seek assistance. And I'm sure that it'll be a very rewarding exercise to do that.
So I'll open it up to the floor for any questions or comments. So please feel free to drop questions in the comment box, or just take yourself off mute and ask it directly.
Mr. James's question, is there any discussion of ad valorem charging? No, it's all on the ICC scale of fees. There is a range, though. There's a minimum and maximum amount, and the court will consider the fees in every single, at different stages of the arbitration. They consider it at the beginning when the first submission is made, and then they consider it in the draft award stage, and they will consider whether or not to increase the fees to the maximum amount that they can under the scale.
And we as the court, and sorry, Joe, and we as the court then have to consider the suggestions made by the Secretariat as to costs, and either approve or disapprove, and then discuss the recommendations as to the costs, as the payment of costs.
Justice Raries? I think you're on mute.
Sorry, I'm not a judge anymore, but
sorry, force of habit.
Sorry, can I ask, under the ICC rules, would the court allow arbitrators, for example, to get the parties to prepare agreed statements of the procedural history, identifying if there is a disagreement about something, and be able to just simply rely on that and plug that into, I know you can't annex it to the award, just bolt it into the award and say, well, that's the procedural history, to get away from any challenge to, you didn't rule what steps in that are necessary to put in. And likewise to, well, maybe it's a different point. What one of you said about the continental system of drafting, do you need to deal with the winning party's submissions as well, or can you simply say, well, I accept the winning party's argument and then give your reasons about that?
I'll answer the first bit of it, if I may, and maybe Joe could answer the second. Stephen, for the first bit, really, the court, the secretariat, the case management teams encourage as much intervention by arbitrators in providing however arbitrators best think the matter should proceed. Indeed, the rules make specific reference to that, the discretion of the arbitrators as to how they wish to run the procedural aspects of the case. You know, we've got openings and closings and all sorts of other in betweens, and all those sort of processes are encouraged, particularly if it's going to, of course, make the proceedings more timely, more efficient, and hopefully less costly. So yes, full discretion.
But the court is very particular, and the secretariat, in fact, is very particular about ensuring a very detailed procedural history at the beginning of the award, and expect the tribunal to do that. On the second question, usually what the awards set out each party's submissions in detail. The level of detail will vary, obviously, on the case, but the level of detail also varies depending on the tribunal. And once they've set out the party submissions, then they will go into their decision. The structure of that can vary, of course, as well. Sometimes they'll set out the submissions on each point and then the decision. Typically, though, you often see that the party submissions are set out as one section, and then the tribunal's analysis is a separate section. And so in that analysis, there's usually a paragraph that says we've considered everything, no matter what we say. But in the analysis section, they'll tend to look at both sides of the argument, may not go into much elaboration as to why they dismiss something or accept something. And then sometimes the court will look at that to see if more reasoning is required, particularly if the process of reasoning doesn't seem to make much sense or doesn't seem to, it's not understandable or comprehensible.
Jenny, I think your hand went up next.
Yeah, thanks. Hi, Joe. Hi, Peter. I wanted to pick up on a comment you made, I think, at the beginning, which is the evolution that you've seen in challenges. And I was sort of keen to get your observations on that, because I think we are seeing more and more challenges. And I think the latest one that I heard recently was an arbitrator was challenged, I think, for attending a lunch with counsel. I think it was an arbitral women's lunch, and there was a photo of that went on social media. So I was wondering if you could sort of comment on the evolution of challenges. And time permitting, I'd be curious, since we have the benefit of you on this call, to have your observations on how the change of leadership, which I think you've lived through in the ICC, but from Alexei to Claudia, I guess, has impacted the work of the court, is, in terms of style, just to have your sort of reflections.
Could I go first, Joe, on the question of the challenges? Yes, Jennifer, as I've indicated, we've been seeing a lot more challenges we've both seen over the last 6 years. And I think in the one you referred to, I'm pretty sure that the challenge was not upheld. But it just shows you the lengths to which some parties are prepared to go, I suppose, putting it mutually, to actually potentially to challenge. Yes, as I said, I think there's a fair bit of guerrilla tactics going on in this exercise, but it's it's a fertile ground. But as I said, very few actually do succeed. But again, they are dealt with very, very seriously and robustly. And of course now, if you ask for an explanation, the court will give you one. I think the rule may say may, but I think invariably we always do actually give reasons where they're asked for as to why the challenge has been upheld or not. So there's a degree of transparency in the process, probably more than there has been historically, because the rules have been updated very much to promote transparency as much as possible. Joe?
Yeah. On the change in leadership, one thing I've noticed, I mean, both Alexi and Claudia have been very involved in the committee sessions. They both run them very, very efficiently. I've certainly been in sessions where they both commented on the particular award or decision to be made and been very involved in the process, which indicated they did read it and consider it. Sometimes also, if they are not party or involved in the actual, they're not present in the committee, the Secretariat will indicate whether or not they've discussed it with Alexi or Claudia, which also shows how important it is to involve them in the process and important to get their view on a particular decision and which way to go. The only difference I could say in terms of seeing the change in leadership, they both were trying to be innovative and make changes to the court. It's very important, obviously, to keep the court moving and to move with the times. Alexi's introduced the idea of gender parity, and so when we were appointed, they got 50-50 male and female members of the court. And Claudia has continued that tradition with introducing new reports in the ICC Commission to consider disability, the impact of disabilities on how to run arbitrations, etc. They issued a report last year. And then the other aspect she's been focusing on is to emphasise all the other dispute resolution services that the ICC has to offer. And there was a report last year as well on ADR and a specific report for clients on how to manage the dispute resolution process, not just managing the arbitration process.
Tim, thanks for your patience.
Not a problem. I hope you can hear me okay.
Yes, you can.
Well, hopefully even better, you can't see me. But my question is this: in the context of people from civil law and common law backgrounds sitting on the tribunal, where there's bitterly fought accounts of through oral testimony of events, so people's credits going to be an issue. I was just wondering whether you could describe how the members of the panel deal with, you know, for example, issues of hearsay and that contest of credit. Just describing in general terms how you found it's been sitting on those panels, but as I say, with people from coming from different backgrounds.
Tim, it helps a lot if we can refer to, and they're only guidelines, but the IBA guidelines on the taking of evidence. I think that's probably a starting point in this exercise. And from then on, I mean, there aren't any formal rules of evidence as such, but those guidelines are very helpful to guide parties through it. But it's a fascinating process, particularly when you sit as an arbitrator and you've got a tribunal made up of both common lawyers and civil lawyers, and then you've got the practitioners who are made up of civil lawyers and common lawyers. And it's fair to say, I think that we see at the court quite a development of it's almost a transnational type approach, if I could say that, in this area to procedure, because it's not just a case of civil or common law procedures. Often it's a combination of both, and I think the court's embracing that transnational aspect more and more.
For example, the tribunals will often be concerned with credibility, but only to a point. If there's no indication that there's any reason to be concerned with a witness's credibility, and for example, a common law lawyer is going down that path, but to no avail, the tribunal might tell them politely to pull back if it's not going anywhere and to ask them to focus on the facts. I think there would, though, be the same level of expectation when it comes to things like hearsay, what they actually recall, all that level of credibility. I think these expectations in civil law and common law would be very, very similar. Another difference, though, is less to do with witnesses and credibility of witnesses, but more to do with the disclosure process, because common law parties and companies in common law countries are more used to giving disclosure and the civil law parties are not. And so they are not concerned about withholding material, even if the tribunal orders them to disclose something.
Rajesh?
Thank you.
Hi, I just want to check with you that do you see any role of ICC Court or Secretariat, or should there be any role of ICC or Secretariat or court in vetting or confirming the translated version of the award if there's any discrepancy? So can they provide any like confirmation in substance or in form whether the translation is correct or not, if there's any discrepancy in translation?
So usually the tribunal and the secretariat, if the award is initially in another language, will get that award reviewed by secretariat members and tribunal members who speak that language. So sometimes the award is only in French or Spanish or Portuguese, and it's reviewed in French, Spanish or Portuguese. So sometimes you're lucky if you attend a court session and 2 awards are in French, that's 2 less awards you need to read. But sometimes the award is in English and then translated into the language afterwards, because the language of the arbitration is that language. And then my understanding is that the secretariat members will still review it and ensure it's going to be translated appropriately.
At the time of enforcement, can we go back to ICC Court and check that if they can give us confirmation that is correct or not?
I'm not sure what confirmation the court would give you.
Okay.
And there's always going to be some debate, because it's only correct in the eyes of the court or eyes in the secretariat, because they're the ones who reviewed it. And obviously somebody else who reads it might read it differently.
Mm-hmm. Yeah. Thank you.
Yes, I would say would need to be done. The process needs to be completed before the actual final award is issued. I mean, we can actually obviously, some subject to functus officio, of course, you can come back and seek clarifications, but I think the proper process would be that any translations would be dealt with in advance of the actual issue of the final award, and allow the parties to then dispute that. And if they want to go and get a second certification, then they do it at that stage. That would be the more appropriate stage than to wait till after the award is issued. I'm not aware of what would happen after. As I say, subject, and so there's questions of functus officio, I suppose, on that as well.
It's not very often, though, that an award is issued in a language that it wasn't originally written in. I had one recently, but that was probably the first that I could remember for a long time.
Yeah. And of course, at the very beginning in the process, there's a requirement to actually confirm, if not that the arbitration agreement says in which language the award is going to be written, and that is then decided at the terms of reference stage. Very important terms of reference stage. Yeah. But I just say, if there's a pause, or if we're concluding that, I think I can speak on behalf of Joe and myself and say it has been a terrific privilege for both of us to represent Australia for the past 6 years on the court, and to be involved in its work. And we both feel that we feel very honoured to have had the opportunity to be afforded this wonderful and unique opportunity. So we'll leave in another month or so. Very happy in the experience which we've had, and we will both be able to, I think, put that to good use in our future arbitration practices.
Thanks, Peter. Conscious of time, we have run a little bit over, so we will wrap up there. But thank you, Peter and Joe, for joining us today and for sharing your insights into the court. It's been a very interesting and insightful session. And thank you to everyone for dialing in and participating. And a quick plug for our next episode, which will be on the 29th of May. We'll be joined by Bronwyn Lincoln and Jessica Crow discussing judicial notice of climate change.